If you were arrested for domestic violence, you are probably wondering how you can keep it off your record. Today, I'm sharing a case study of how someone who was once in your position was successfully able to get his charges dropped. I'll walk you through the key steps that he took and the strategies that you and your attorney can use to work toward the best possible outcome. My name is Veronica. I'm a domestic violence defense attorney and I represent clients throughout the entire state of California. I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to know to represent yourself at a restraining order hearing and win. So if that is something you're dealing with, in addition to dealing with a criminal case, make sure that you get your free first class via the link down below. Okay, so let's jump right in. I know that facing a charge like this can feel really overwhelming, especially if you've never been arrested before. Maybe you've never even gotten a parking ticket. It might feel scary, it might feel hopeless, and look, it is scary, but it's definitely not hopeless. So let's go through our case study and talk about steps that you and your attorney can take that really will make a big difference in the outcome that you get. And this case study is fictionalized to protect confidentiality, but the steps and the strategies are real and are inspired by cases that I have had and steps that I have taken to protect my clients' futures. So let's get into it. First, immediate action. Taking immediate action is so important. First of all, if you have not been to court yet, an attorney can potentially help you get the case dropped before court. But even if it's too late for that, if charges have already been filed, you want to show the court that you're committed to making changes. This might mean enrolling in domestic violence classes, starting therapy, there's alcohol involved, going to AA, couples counseling, things like that. Now, I know that this may seem counterintuitive because if you start going to therapy or couples counseling or DV classes, then doesn't that mean that you are guilty? Aren't you admitting that you have a problem? The answer to that is no. Look, you want to make changes so that you don't get arrested again, right? So you never end up in this situation. If you and the alleged victim are going to stay together, maybe you just had a loud argument, but there was no domestic violence. Okay, well, it was loud enough that the police did end up responding. And so you do want to make sure that in the future that doesn't happen. And it's not taken as an admission of guilt by the court system. Instead, it shows that you are proactive, that you're taking this seriously, because believe it or not everyone who is in your position does take it seriously. And it gives them a little bit of added assurance that nothing like this is ever going to happen again. Now, let's get into our case study. Daniel was pretty shaken up after he got charged. He didn't know what to expect, but he knew that he needed to act fast. His lawyer advised him to get into court-approved domestic violence classes right away and to start therapy. And since alcohol was a factor in his case, he and his wife had both been drinking on the night of the alleged incident. His lawyer also told him, hey, start going to AA. It's going to look really good for you later. At first, it felt overwhelming. His lawyer had sent him to 3 different types of classes. Plus, of course, he still had to work and live his normal life with his normal responsibilities. But he kept showing up. He kept doing it. And over time, he built up documentation of his progress and of his commitment to making sure that he never got arrested again. And those records ended up being one of his biggest assets later in court. All right, so you've started to build up what's called mitigation, basically good things about you, and steps that you have taken to make sure that you don't end up arrested again and that show the court that you don't want to be part of the criminal justice system and you don't belong there. Next is evaluating the evidence. Now, of course, this is something your lawyer should be doing, and your lawyer should also share the evidence with you. Now, if there's really strong evidence against you, and sometimes there is, that doesn't mean that you should give up. That doesn't mean that you should plead guilty. It does not mean that you are out of luck. And sometimes strong evidence doesn't actually even mean that you are guilty, but things like consistent statements on the part of the alleged victim, an actual injury, things like that, as opposed to the victim, say, making 3 different statements and having no visible injuries. It does make the case harder to fight. But if the case against you is really solid, then the strategy may shift to, instead of fighting the evidence and saying this is a false allegation, to showing the court the positive steps that you have taken since the incident. Look, a big part of getting the best possible outcomes in these cases is not giving up. Now, going back to our case study. In Daniel's case, there was video of the incident, and unfortunately, Daniel gave a statement that he thought was in his favor to the police, but actually amounted to a confession. The big issue in his case was whether or not he was acting in self-defense, and both his statement and the video showed that he used excessive force, which does not count as self-defense. Now, as an aside, depending on the circumstances of when he gave that statement to the police, the lawyer might want to file a motion to suppress. But Daniel's lawyer didn't give up and saw a different path. Instead of trying to fight the evidence, they focused on building a case that showed how much Daniel had changed. By this point, the classes and the therapy, they had become part of his routine, not just something that he was checking off a list. His lawyer explained that progress and the proof of all of that progress could be his path to keeping his record clean. Okay, so now you are building up your mitigation. Your lawyer has evaluated the evidence. The next step is going to be talking to the district attorney and negotiating. And I'm not saying negotiating as in give in or plead guilty. The initial offer from the district attorney often will come with not only a guilty plea or no contest plea, but jail time, probation, and all of that comes with a criminal conviction and having a criminal record. So you need to have a strategy to negotiate a better deal so you are not giving in to jail time and you are not potentially throwing away your career with a criminal conviction. But sometimes it is a slow and stressful process. So turning to Daniel. Without Daniel's lawyer even asking the DA gave him the initial offer. It was 60 days in jail, 3 years of probation, and that would come with a misdemeanor domestic violence conviction. He has no criminal history, and except for his one night in jail before he was processed and bailed out, he's never been to jail. He doesn't belong in jail. But his lawyer told him, look, accepting the very first offer from the DA is like paying sticker price on a car before COVID and before the chip shortage. You shouldn't take that first offer. We're going to keep building your mitigation and we are going to negotiate. Daniel's attorney then set up a meeting with the DA's supervisor. In most counties, there is the DA who's assigned to the case, and then they have a supervisor who can give you a better offer. At the meeting, Daniel's lawyer explains all of the mitigation, everything that Daniel has been building, and how he's trying to avoid a conviction. And at the end of the meeting, the DA supervisor gives an offer that is better. It's a reduction to a battery charge, which means that there would only be 1 year of probation, whereas with the misdemeanor domestic violence probation, you'd have 3 years of probation. That means that it can get expunged at the 1 year mark. The DA supervisor also takes jail off the table. And look, if the evidence is bad, that is a good offer. So Daniel's attorney takes that back to Daniel, and Daniel says, okay, great, I'm going to just take that offer. But the attorney says, Daniel, I really think that you should wait. Let's see if we can completely avoid a conviction. Keep going to your classes, keep going to AA, keep going to therapy, and let me work. Daniel's nervous about this, but he tells his lawyer, okay, I trust you. So Daniel's been building his mitigation, the evidence has been evaluated, and we have an offer from the DA's supervisor it's a decent offer in light of the fact that there's bad evidence, but it's still involves a conviction. And yes, it can be expunged, but potentially that still could come up for Daniel. And it can't be expunged while he's on probation. Now, in criminal cases, there's something called mental health diversion. Basically, how it goes is that your attorney writes a motion explaining why you should get mental health diversion. And if the judge grants it, then you complete mental health treatment for some period of time, and then you get the case dismissed. You don't have a conviction. But how does this involve Daniel? Daniel so far seems pretty sane, right? I mean, I haven't told you that much about him, but he has a steady job. He has no criminal convictions. But at the courthouse, Daniel's lawyer tells him, Daniel, I've noticed that you seem very anxious lately. You've been going to therapy. It seems like that's been helping a bit. And Daniel says, well, yeah, of course I'm anxious. I'm facing this criminal case. And I think I was anxious even before this whole thing happened. That's probably what contributed to me drinking too much and this whole incident happening and me getting arrested in the first place. And his lawyer says, okay, perfect. Great. I'm very happy to hear that. I want you to go and see a psychiatrist, okay? Talk to the psychiatrist, tell them how you're feeling, and I want to see if they diagnose you with anything. If they do, I want to see that paperwork because I have an idea. I want to see if we can get you qualified for mental health diversion. His lawyer explains exactly what that is to Daniel, and Daniel's a bit skeptical, and he's like, come on, level with me. Should I just take that battery conviction? I appreciate you're trying to help me here, but should I just go for that? At least it would just be 1 year. I mean, I don't think mental health diversion, I don't have mental health. I don't think that's for me. His lawyer says, just go to the doctor. And let's just see what happens, okay? That other offer, if you want to take it, you can, but let's just see what we can get here. Daniel says, look, I've trusted you this far, so okay, I'll do it. So Daniel does go, and he sees a psychiatrist. And lo and behold, he is diagnosed with anxiety and with depression. His doctor does give him a low dose of medication that does actually make him feel better. And he gives that documentation to his lawyer. His lawyer is able to use it and files a motion for mental health diversion. Usually part of this process, as a defense attorney, is getting the DA to agree not to object or oppose the motion. And so the next step is that the attorney sets yet another meeting with the DA supervisor, because this time the attorney has something new to share with the DA supervisor to discuss the mental health. And now several months have gone by. Daniel started early and was consistent. Now he has months of records where he's been going to therapy, months of records where he's been going to AA, and months of domestic violence classes. What it supports here is that this claim of needing mental health treatment, this is not a recent claim. This is not a fabrication to get the motion for mental health diversion passed. No. This is real because he's been going from the very beginning. And now he has a diagnosis from a psychiatrist, so this adds credibility. So when Daniel's attorney goes and talks to the DA supervisor, another benefit that he has is he's not asking for an offer anymore. He's not asking for the DA's office to put themselves on the line and give Daniel an offer. No, he is just asking for them not to oppose his motion for mental health diversion. That's it. Just don't oppose it. Just don't try to block me. And after some consideration, the DA supervisor agrees. The court holds a hearing on the motion for mental health diversion, and because of all the credibility that Daniel has built up, because the DA's office is not opposing the motion, and because Daniel has shown that he is persistent, that he really cares about his future, and that he will comply with whatever mental health terms they give him, the judge grants the motion. Daniel is to continue his current treatment for 1 year, and at the 1 year mark, provided that he's done everything that he is supposed to, the case will be dismissed and he will maintain his clean record. As the months pass, Daniel sticks with the program. He keeps going to his therapy, which is online on a weekly basis. He's able to do it after work from the comfort of his home. He keeps seeing the psychiatrist who ultimately determines that he doesn't really need medication anymore now that all of the anxiety of the case is gone. And he feels immense relief that he has avoided having a conviction and feels proud of himself that he stuck with it even though it was very scary. So 1 year later, Daniel's case was dismissed just like he and his lawyer had planned. He walked out of court with his record clear, his future intact, and this whole situation behind him. Look, Daniel's story shows how starting early on, treating any issues that anyone might even suspect you of having, strategic actions, and persistence can be the difference between having a conviction on your record and having the case dismissed. I've had the privilege of helping many clients in similar situations. We start early, we fight hard, and we don't give up. And that is how you get the best outcomes in domestic violence criminal cases. If you are dealing with a situation like Daniel's, don't wait to take action. You're already here, you're researching. While you have that momentum going, get an attorney. It is going to make everything much easier for you when they give you clear guidance on exactly what you need to do. And make sure you find someone that you trust so that when they tell you, hey, I don't think that you should take that deal, I think I can get you something better, let's keep trying, you feel comfortable trusting them. And knowing that they know what they're doing, that they care about your case, and that they are going to do whatever is in their power to protect you. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation via the link there. And if you did find this video helpful, please don't forget to like, subscribe, and ring the bell. And if you have a question, leave a comment.